Us. We're going to be getting started here in just a few minutes. All right, well, welcome everybody to Community Perspectives on the Chauvin murder trial and justice in that context. My name is Sarah Davis, and I'm honored to serve as the Executive Director of the Legal Rights Center. Thank you for joining us for this critical community conversation on justice in the context of this trial. I'm going to ask my colleague, Andrew Gordon, here to just start sharing his screen again so that you all can learn a little bit more about the Legal Rights Center as we get started here. I'm going to go through this fairly quickly because we only have about an hour together tonight. The Legal Rights Center is a community nonprofit law firm in Minneapolis, founded in 1970 by the Black and Native American communities in Hennepin County, and later joined by immigrant communities as well. Legal Rights Center continues to be led and operated as a community-driven organization, and it is our mission to work with our communities to seek justice and promote racial equity for those to whom it has been historically denied. Today's forum is a part of our ongoing work focused on being responsive to community legal needs. We are now in the second week of Derek Chauvin's trial for the murder of George Floyd, and there's a critical need for accurate and accessible information about this trial from a trusted source. This forum is just one in a series of events and educational resources that LRC is supporting over the coming weeks. Please check out our website to access our educational videos, learn about upcoming Q&As with our attorneys, and restorative processing spaces. It is now my honor to introduce you to our panelists for today's forum. Nekima Levy Armstrong is a civil rights attorney, activist, national expert on racial justice, former law professor, and legal scholar. Nekima is also the executive director of the Wayfinder Foundation, which provides support for women of color activists and organizers around the country. She is also the founder of the Racial Justice Network. Mary Moriarty is the former Chief Hennepin County Public Defender, a role she served in for 6 years. She's also a faculty member at Gideon's Promise and a faculty of public defender trial skills programs across the country. She teaches at Harvard Law School Trial Advocacy Workshop, the National Criminal Defense College, and she teaches right here in Minnesota at the University of Minnesota Law School. Mark Osler is the Robert and Marion Short Professor of Law at the University of St. Thomas here in Minnesota. His writing on clemency, sentencing, and narcotics policy has appeared in many national publications. He's also a former federal prosecutor and won the case of Spears versus United States at the United States Supreme Court, with a court ruling that judges could categorically reject a mandatory 100-to-1 ratio between crack and powder cocaine in federal sentencing guidelines. And lastly, Andrew Gordon is LRC's Deputy Director for Community Legal Services. Andrew was born and raised in Kingston, Jamaica, and he is dedicated to his career to advocating for and empowering communities of color, immigrant communities, and other marginalized communities. He understands that there's nothing that separates him from the plight of his clients and their families, and we are deeply honored to have Andrew on our team at LRC. With that, let's get started with the panel. Andrew, if you could pull down that screen share and we will spotlight our panelists here. Tonight, we're going to be talking about a whole variety of things that have happened over the past week in Derek Chauvin's trial. We're going to start off by talking about third-degree murder. Mary and I was wondering if you could start us off here. Originally, Derek Chauvin was charged with third-degree murder, and then that charge was dismissed on a motion for lack of probable cause, and now the charge has been reinstated. Can we talk about what happened and what it might mean for the trial?
Right. I think most people that followed Mohammed Noor's trial and the conviction on the third-degree murder and are familiar with that statute expected the Court of Appeals to reverse his conviction on that because it doesn't fit what happened there. And that's why Judge Cahill dismissed that count for lack of probable cause. And then right before the trial started, the Court of Appeals in a 2-to-1 decision affirmed Noor's conviction. The AG's office asked to reinstate the murder, and Judge Cahill said no because he didn't think it had the appellate court had precedential value that he had to follow, and he also said it didn't apply. He agreed with the dissent in that case. And then they went up on appeal again, and essentially he was forced to reinstate that charge. It's still problematic because it doesn't seem to fit at all what the actions are. And I think it creates issues, potential issues down the line. For instance, if Chauvin was convicted of that and nothing else, the Supreme Court has already taken up the Noor case. And so they would have to decide whether to affirm those convictions for third-degree murder because it really doesn't apply in either Noor or Chauvin's cases.
Andrew, I was wondering if you might jump in here and talk a little bit about what the concern is in the long term, if that, with the impact of the Noor appeal.
Yeah, I think Mary kind of alluded to this just now in her response to this particular topic. I think the nightmare scenario, right, is that let's say this trial process continues and Derek Chauvin is convicted of the third-degree murder charge, and that's the only thing he's convicted of. One could easily envision a scenario where the Supreme Court of Minnesota overturns the decision in the Noor case, and that the overturning there would then have a trickle-down effect and a very significant effect on the legality and lawfulness of any conviction for third-degree murder in Chauvin's case. That's kind of the nightmare scenario, where then Chauvin all of a sudden is found not guilty or not responsible because the charge he was convicted of no longer applies, right? And I think the sentiment that you would get in the community then is that of an injustice. And that would only play into the frustration and the trauma that I think the Black and Brown communities in Minneapolis, in the Twin Cities, have suffered through over the generations.
Nekima, would you be interested in jumping in here, share a little bit about community legal perspective on this third-degree murder charge and this nightmare scenario that Andrew talked about?
Sure. I think that for those of us who watched that gruesome video of Derek Chauvin choking the life out of George Floyd by pressing his knee into his neck for over 9 minutes, thinking about the threshold and how low it would seem regarding this third-degree murder charge if that were the only thing that Derek Chauvin were convicted of. So for example, if an officer in the future shoots someone in a split-second decision, if we could not convict Derek Chauvin on second-degree murder, what does it say for that officer in that situation? The chances of him being convicted are slim to none. The seriousness and the gravity of this particular case, the fact that it was caught on video, from my perspective, raises the bar in terms of accountability, not lowers it. And I know that prosecutors are hoping that if a jury feels that Derek Chauvin's conduct doesn't rise to the level of second-degree murder, they want another option in order to convict him. But like Mary said, it doesn't fit. And it also lets officers know, once again, that they will be protected when they violate people's civil rights, civil liberties, and when they kill people. So that is a huge concern that I have about this edition of the third-degree murder charge.
Yeah, and I'm going to jump in here real quick, not necessarily to respond directly to Nekima, but to really talk about some of the questions from the audience. We're seeing questions both in the chat as well as some folks are using the Q&A function. And something Nekima just mentioned is a question that we got in the Q&A. The question from an anonymous attendee was, can you explain why the third-degree murder charge doesn't fit? And Mark, as our kind of designated prosecutor on the panel, I don't know if you want to take this one up or if someone else wants to jump in and answer that question.
So the question is, why would it be seen to not fit this case? Well, the question, and this is what was raised in the Noor case, is that that statute talks about an act that's eminently dangerous to others. It uses the plural. And based on that, there's been the view that that is a crime only if it's a general danger to more than one person. If you're driving along and shoot at a crowd, for example, and you're reckless in that way, not when you have one specific possible target. This was true in the Noor case where there was one person there, or was true here where Derek Chauvin had his knee on one person's neck. One thing I do want to mention is that I think that the nightmare scenario has a second level to it, which is that it's probably unlikely that he would be convicted just of third-degree murder, but he'd also be convicted of second-degree manslaughter. But the thing about second-degree manslaughter is that the penalty is very low, that the guideline sentence is about 4 years, which means that he would be out of prison a little over 2.5 years in. And I think that would be seen as a real injustice. The other thing that we have to remember is that were third-degree murder to be the main charge of conviction and that to be stricken down, then we'd have a really serious question of whether the federal government should take it up as a civil rights violation, which they can. And that makes the decision about who the new U.S. attorney is here very important.
Thanks, Mark and all. I don't know if anybody else wants to jump in on that conversation, Mary or Andrew, but is there anything else to say on third degree before we move forward to talk a little bit about jury selection?
Yeah, I was just going to say that there was a lot of anger in the community that former officer Noor was actually charged with attempted or second-degree murder, intentional second-degree murder. He was acquitted of that, but he was also charged with a third degree. If Chauvin ends up being convicted of the third degree, I think most people would look at those two acts and believe that Chauvin's actions were much more severe than Noor's actions were. And I suspect that would cause a lot of anger in the community because Noor was the first former officer who was held accountable, and he was Black and the person he killed was white. And here we have a white police officer who killed a Black man. And I can see anger if they end up being convicted of the same charge because the facts don't seem to fit, or Chauvin's facts seem to be much worse in many people's eyes.
There was a question in the chat related to what the implications are for the other three officers and whether they will be tried. I mean, I have a lot of questions about whether they are going to be tried, especially if an acquittal happens and or if the only charge that sticks for Chauvin is third-degree murder. Judge Peter Cahill declined to make a decision regarding the third-degree murder charge as it pertains to the other three officers who aided and abetted Derek Chauvin. So it's up in the air and it's a fair question.
Thanks, Nekima. I don't know if any of our other panelists want to comment on how this, how you expect this to play out with the other three officers who are former officers who are scheduled to start trial in August.
I think what you would expect, if there is an acquittal, or even if Chauvin is convicted of just a third-degree charge, the other officers are charged aid and abet. And to be fair, I think Chauvin is also charged aid and abet, even though he clearly is the principal. And I think a jury in the other officers' cases, or case given it's a single trial, could look, even in the face of an acquittal for Derek Chauvin, and still look at the other officers' conduct as being unlawful because it may have aided or abetted something else. And I don't think it necessarily requires, depending on kind of the way you look at it, it doesn't necessarily require what that other thing is, as long as that other act is unlawful. I think if Chauvin were acquitted, there's very little chance you see a second trial involving the other officers. If there is any conviction on the front end, there's likely going to be a trial for the other officers, whether that's in August or later on this year or next year, we'll see.
Thanks, all. Well, let's shift gears a little bit here. We're now in our second week of jury selection. And, you know, with this being live streamed, I'm sure folks have a lot of questions about what's happening in jury selection. I point our audience to the educational videos that our office put out on this topic. There's one very specifically about how jury selection works, the differences between challenging a juror for cause and peremptory challenges. We'll drop the link into the chat so folks can access that later. But let's jump right in. You know, we saw some really interesting things come up today as it relates to jury selection and then the civil settlement that was announced by Minneapolis on Friday. The defense made a motion related to this, and we saw jurors excused because of it. Andrew or Mary, I wonder if one of you could jump in and get us started on what happened there.
The defense actually made a motion in limine, basically asking the court to exclude any evidence of civil settlement. I think he was aware that an offer had been made. This happened last week. And so he asked the court to exclude evidence of that. The state agreed because everybody knows that lawyers, they knew that the evidence in the civil case, any settlement, was not admissible in the criminal case. Although I'll say settlement discussions in the criminal case are not admissible at trial either, but that got out there in the New York Times article about Chauvin apparently agreeing to plead guilty. So he had made the defense had made a motion to exclude that. The judge granted it. And then suddenly you had this announcement Friday. And not only was it an announcement for a historic settlement, but it had all of the city council, the mayor, the city attorney, a whole group of people. I don't think there could have been worse timing for that. If you've been watching, you know that the parties are trying very hard to ascertain what each of the jurors has been exposed to and whether they have opinions and whether they can set them aside. And the issue here, if you heard Nelson this morning say this is the third time that something like this has happened, and I think he was referring to the convening of the federal grand jury, the leaking of the plea agreement, and now this settlement. And the big concern is that they've already seated 7 jurors, or they had as of this morning. And so what the court had to decide was, what do you do about it now? Because he has ordered those 7 jurors not to tell anybody they're on this jury panel. So it's very likely that somebody would say, hey, did you hear about that settlement? It is extremely likely that they will be aware of it. So what does he do? And you could see what he did today with the prospective jurors. He was dancing around it. He had a couple of choices. He could say to the jurors, there was a settlement in this case. Did you hear about it? What does that mean to you? That sort of thing. But you could see he was dancing around it because he didn't want to come out and say it to the prospective jurors. But what he did decide is they're going to call in those 7 jurors who were already seated, and they're going to have to ask them questions about whether they became aware of this information. So really, couldn't have been worse timing. Maybe one of you guys is familiar with whether that was something that had to be announced because it was public money. Why couldn't they wait until after the trial? I don't know the answer to that. But from a criminal trial perspective, really awful timing. And for the prosecution too, because it potentially creates an error where if Chauvin is convicted, the appellate court would be reviewing that. And if they thought it was a big enough error, they could reverse his conviction and send it back for a new trial.
Yeah, and I think one thing to note too is we don't have to speculate what impact this might have on a juror. One of the jurors today who was called said that she heard about the settlement and gasped. And it was shocked by the amount of it and that it would impact the way that she thought about the case. So already it's come into play.
What was interesting about her too is that she was in HR, and she actually knew the difference between proof beyond a reasonable doubt and other standards they use in civil cases. But she still said that meant to her that the city didn't think it could win a civil case. So even somebody who was relatively sophisticated about the different standards of proof and different avenues for the civil case and criminal case said that knowing that she could not be fair.
Yeah, and to follow up on that real quick, Nekima, and because there's a question in the chat with respect to could the potential settlement announcements influence jurors? Could that cause a mistrial to be cleared? I think that's certainly one of the concerns. And something that you saw happen this morning is that Chauvin's representation, Eric Nelson, renewed a motion to move the case out of Hennepin County to change the venue. Those are the types of discussions that I think you're going to see pick up pace in the next few days, especially if more and more jurors come in and say that they've heard about the settlement and it's influenced them. And so I apologize for jumping in there, Nekima. I just wanted to get that out there real quick.
No, I think that that's fine. I mean, my perspective has to do with the impact on the family in terms of having to wait for the outcome of a trial like this in a system that is inherently unfair and racially biased. The pain that they've already been through in knowing that millions, 50 million plus people have watched their loved one die on camera. 26 million people took to the streets. The family is in immense pain. I could see it. I attended the press conference on Friday. And when they were on stage talking about the settlement, they were crying, several of them, because they were thinking about George Floyd and saying that if they could give the money back in exchange for George Floyd still being alive, that's what they would choose. So I'm not sure of what happened behind the scenes in terms of why the city decided to settle this case at this time, but I'm sure that the family wanted to have that portion of the legal proceedings that they were involved in be addressed. Because imagine having to wait on the outcome of a trial, knowing that the deck is stacked against people who have been killed by police and stacked in favor of police who kill, and that could determine how the city sees the value of the life of your loved one. So we have to also consider that in addition to the other concerns that my fellow panelists have raised.
Thank you so much, Nekima, for bringing in that perspective. And it's right, so important that we have you here. I wonder, if folks, some of the criminal attorneys on the panel might talk a little bit about, what you heard from Nekima and then how you put that in the context of the concerns that have been raised. Whether it's, we have some questions about, is it too late for a change of venue? We have folks asking about a mistrial. There's justice from a community perspective as it relates to the civil settlement, and there's justice in this criminal context, and how do they interact?
There was some speculation about what could this mean to jurors, and one way it could go would be that a juror would think, well, the Floyd family has a settlement, so is a conviction really necessary now? I've heard that as being a potential cause about this. I don't see a change of venue happening at all, given Judge Cahill's previous rulings and writings. One thing, I see a question there, the man killed George Floyd, why are we dancing around on Chauvin or around Chauvin's rights? And I understand that sentiment, but I actually think it's so important that Chauvin receive a fair trial. If people we don't like or we think should be convicted don't get fair trials, that always lands on our clients, public defender clients, poor people, people of color. And so and I say this knowing that often people of color don't get a fair trial. I understand that completely. But to me, the answer is not to cut corners on the rights of a person who's despised by many in the community. And that's one of the supposed to be one of the cornerstones of our system, that no matter who we're talking about, they get a fair trial. And so that's why dancing around his right, trying to make sure that he has rights. And what kind of a message does that send? I mean, I would want him to get a fair trial. I would want the country, the world to see, look what happened here in Minneapolis, yet jurors stood up, gave him a fair trial, and he was convicted. That would be a compelling message, that he could get a fair trial here, given everything that's happened.
I think it could be a compelling message, but that still will not, and I agree that he should have a fair trial. That will have absolutely nothing to do with whether Black people and other people of color get a fair trial, especially poor people of color within the Hennepin County judicial system. So yes, from a perspective of having principles about the system, sure. From a practical perspective in terms of what will happen, nothing.
Yeah, I agree with you. And it does make me think of a client I had years ago, a Black man. We were waiting for the jury panel to come up, and they were all white. And my client turned to me and said, "Is the offer still available?" He pled guilty. He looked out at the sea of white faces and did not think he could get a fair trial. And so I agree with you. I certainly, being in public defense for 31 years, have seen what has happened to Black and brown people. And I agree with you completely, Nekima. And so that's why I think for many of us, it's, trying to balance this, trying to believe that in a system where we want people to get a fair trial, even a Derek Chauvin, while we know that so many people in the system do not.
Going back to Nekima's point, I think that I hope that was part of what the city was doing, was recognizing the urgency of justice, and that the civil and the criminal tracks are not connected, and that's important to recognize, because there's been allegations out there of Keith Ellison and his son conspiring and things like that I think are hogwash. That these two things are running on separate tracks. Criminal justice often takes time. The civil settlement, I think, Nekima, you identified a core equity there that hopefully was taken into consideration.
Yeah, and one of the things I want to kind of jump in as a way to kind of combine both what Mary and Nekima are getting at is that there is kind of the thought in the legal sphere that, right, we want to premise the idea of a fair trial. And when we think about a fair trial as attorneys, as folks who work in the court system, we're not necessarily thinking about the experience, the lived experience of the individual who is participating in that trial and who is suffering through it. So the person who's charged with a crime. And irrespective of what happens with Derek Chauvin's case, right? His lived experience of being involved in the criminal legal system is not necessarily going to mirror the lived experiences of someone who is Black, someone who is brown, or you can imagine it would not have mirrored the experience of George Floyd had he lived and likely been charged with obstruction and who knows what else to justify Derek Chauvin's action last year, right? So when we talk about fair trial, we're not talking about or trying to excuse away the fact that those lived experiences are incredibly different. And I want to segue from that then into some of the questions that folks have had in the Q&As and in the chat with respect specifically to venue. Is it too late to change venue? Why would that be important? It's not too late to change venue quite yet, especially if a mistrial is declared in Hennepin County. And the reason that's important is because for all of the failures of the jury selection system, for all of the failures of the jury summons system, a jury in Hennepin County is still much more likely to be receptive to watching the video of what Derek Chauvin did to George Floyd, being outraged by that, and rendering what we all think, I think, is a fair verdict, right? A conviction. A jury in Couchiking County, who knows? A jury, somewhere closer to North and South Dakota, on the western border of Minnesota, who knows? But it's safe to say that a jury pulled from a county outside Hennepin is going to look and feel and act very different with respect to watching Derek Chauvin put his knee on George Floyd's neck, keep his knee there, and effectively harm George Floyd with indifference, right?
I'd love to believe that. As someone who lives in Hennepin County, who has gone into courtrooms and have seen lots of Black and brown people sitting there waiting for their cases to be called in Hennepin County, where you have primarily white judges, primarily white prosecutors, primarily white public defenders and defense attorneys, primarily white bailiffs, court clerks, security coming into the courthouse. It feels a lot like going into a courthouse or a county that is not as diverse because of the racial implications of how our system is structured. So I understand what you're saying from a practical perspective. And of course, for me as a person who grew up in Los Angeles in the era of the Rodney King beating and seeing just the push to move the trial of the officers who beat Rodney King outside of LA County into Simi Valley, and seeing the implications, right? The intentionality behind moving that trial into a community that was overwhelmingly white and retired police officers and family members of retired police officers. So they got the outcome that they were expecting. But I think with Minnesota being 84% white, again, the deck is stacked against the dead Black victim, regardless of the county. Although with Hennepin County being more diverse than many of the other counties, the hope is that we will get a jury that is reflective of the diversity and the different perspectives that can administer justice at the end of the day. But as Black people having to contend with the way that the system is structured, whether it's in Hennepin County or somewhere else, we still have concerns about the justice system and the scales of justice being tipped in favor of those who have done harm to our community.
To attach some data to that, we had been doing, in Hennepin County, had been doing trials during COVID for quite some time. And we were seeing, our lawyers were seeing what seemed to be more whiteness in our jurors. And I looked at some numbers, and it appears that the participation of Black jurors had dropped about 2% down to 6%, which tells you, we really don't have that diverse panels anyway. And the thought was that perhaps, and Nekima, I think you and I were talking about this before on another panel, that there are Black jurors who are opting out because of COVID and economic conditions. They can't afford to be here. So that's a problem. What we've also seen an interesting thing happen here. It is usually the defense who's challenging the prosecution for removing potential jurors of color. It's been the other way around here. And so the state, I think, has made 2 Batson challenges against the defense for removing jurors of color. And what that means is the state has contested the defense's attempt to remove them. There's a process you have to go through, but essentially the Judge Cahill has denied those. When I've had that happen, and I'm sure Andrew has had this experience too, when prosecutors remove Black jurors or brown jurors and I make a Batson challenge, what I often hear, the prosecutor is supposed to come up with a race neutral reason. And unfortunately, what I hear, and I'm sure you hear too, is that this person has had bad experiences with the police, or they have a poor perception of the criminal legal system. And I think, well, I don't think I know many Black men who have had positive experiences with the police. Who hasn't? How many Black people in our community have a positive perception of the system? And so it seems to me that by virtue of the experiences that you have because of the color of your skin, prosecutors are allowed to remove some of our jurors. And so I think that's a problem that needs to be addressed, because we're losing some diversity there because of those peremptory challenges.
Mark, would you weigh in here a little bit too from a prosecutorial perspective, both on what Mary shared about Batson challenges, but also some of the concerns that Nekima has been raising about about the implications of the racial makeup of the folks who are participating in the process.
Yeah, I mean, there's no doubt that, walking into the Hennepin courthouse isn't so much different than being out county in those ways. And, in regard to Batson, the problem with Batson is that it rarely works, even when it's pretty clear that there's racial bias at work, that people are targeting someone by race, because it's very easy for the side that's being challenged to come up with some other reason. I did a little study on this, and I was surprised by the things that worked to protect people against Batson challenges. It wasn't really their race; it's where they went to church, and things like that. And of course, now that people know and have mastered the process, they prepare themselves preemptorily to be ready to respond to a Batson challenge. And the biggest problem that we have is nationally trying to get better and more representative jury pools. In a lot of states, they will draw the jury pools almost entirely from voter registration lists, and these are places where they've inhibited voter registration in minority communities. And so you have, built on top of a bias system, another bias system, that because we've inhibited voting registration, it inhibits jury service as well. So while any one case can show us a bit of the problem, to step back and see the whole of the problem is really important too.
I wonder if we could bring it back specifically to this case. There's a lot of questions coming out in the chat and in the Q&A about the questionnaire and about the specific questioning that folks are seeing happen in this case. And so I wonder if anybody could comment a little bit on what you've seen happen here so far. If, from your perspective, is there anything that's been positive or things that are raising concerns for you in whether it's the questionnaire or the questioning that you're seeing happen at the live stream?
At first I wasn't a fan of live streaming this, and I can't say I still am a fan, but I will say it has given the public an insight into what actually happens in jury selection. I think people just never thought about how a jury actually comes into being, and they now understand the types of questions that are asked. That questionnaire had questions on it I've never seen on a questionnaire before, like, what do you think about Black Lives Matter and Blue Lives Matter? I think it's a good opportunity for the public to view what's happening. I think since practically everybody has been exposed to this case, and most people are saying they can set aside their views to be fair, and I'm sure they will try. You wonder whether that's actually true, but I suspect the lawyers are basing their answers more on the philosophies of people, because they're asking a lot about what do you think about Black Lives Matter, Blue Lives Matter. So trying to get at those philosophies. What do you think about defunding the police? What do you think about how Black people are treated by the system and the police? So I think those are actually almost more important questions in deciding whether to exercise a peremptory challenge. But the flip side of it is some of those jurors are terrified. And we know just generally, most people don't like public speaking, and they express that when they come in and they're on a jury. And now, even though they're not being shown, some of them are really, really nervous. They've talked about their safety. They've talked about people knowing who they are at some point. And you do have to wonder what impact that's going to have on them. They are not driving in by themselves. They're being picked up at an undisclosed location by sheriff's deputies and brought in. And there's been discussions about the fortifications at the government center. So you do wonder what impact all of this is going to have on jurors.
And just to jump in on that real quick, because it came up today during the questioning, Judge Cahill intimated that he will consider full sequestration, not just for folks who are impaneled as jurors, but for individuals going through the voir dire process or going through the jury selection process, largely because of what happened last Friday. But it was something that caught my ear when he said it, that he's considering effectively pulling this panel in, taking them apart from their families, holding them up at a hotel somewhere, and keeping them apart from everyone else until this process is finished.
His initial order on that left that open, but it's a little unfair to the jurors who've been told to go off and go about their lives. So I don't know how much he's considering that. I'm sorry, Nekima.
No, go ahead. I was just gonna say, from a racial perspective, thus far out of the 9 jurors, one is a Black man who is an immigrant who came to this country 14 years ago. Apparently there is a Black man in his 30s who may be a native-born African-American man. There was a Black woman dismissed by Judge Cahill, I believe, on Friday, after talking about watching the video and just the impacts that that would have. And I believe that Judge Cahill himself made the decision to remove her from the jury. So as of right now, we have a woman of color whose racial identification is unspecified, but it appears that we may not have a Black woman thus far on the jury. There have been a lot of concerns in the community about whether or not folks who identify as Latinx are facing additional discrimination. There was a woman last week who spoke English as a second language, and she was struck from the jury pool. And I just felt that the way that she was treated seemed to be discriminatory, in the sense of the defense acting as if the woman was not sophisticated enough to understand the proceedings and what was happening. And so the community responded by holding a demonstration downtown today to talk about some of the potential bias that they're seeing come forward through the jury selection process. And also, some of the jurors who were selected early on have ties to law enforcement. I think at least 3 have ties to law enforcement. And so, of course, that is of concern as well in terms of how the jury pool actually shakes out. For those who don't know, they're looking for 12 jurors and 2 alternates. And thus far, 9 of those 14 individuals have been selected.
I think the word lack of sophistication actually was used in reference to her, which was troubling. And one thing that struck me about her, she did have some opinions, but it struck me that she wasn't quite as familiar with and didn't maybe understand the question that the defense was asking, or other jurors who were more savvy maybe, and that's not a knock towards her, but knowing to say, yes, I can set my views aside. I wonder whether she knew that that's what the defense was asking. So she didn't have an opportunity to say, yes, I have these feelings, but I think I can set them aside just like anybody else. So I agree. I was troubled by how she was questioned, and I think there should have been more effort to make sure she understood what she was being asked. And I think it's because of the language. It wasn't that she wasn't sophisticated. It was clear that English was her second language.
Yeah, sorry, go ahead. 1 second, Mark. I just want to say that I did follow this morning, and I'm not totally sure that I heard that Judge Cahill say that he would sequester folks during the impanelment. I heard that it would be potentially through the trial itself and through the deliberations, not just the deliberations, but anyhow, I don't know if I was in and out this morning, so if others heard differently, but Mark, go ahead.
No, I was just going to say, Mary, that was one of the first few potential jurors was called. And I remember that. And I was really surprised that she was struck for cause, that because she did understand what was being said, and she answered the questions in a thoughtful way, I thought. So I was really thrown by the fact that she would be struck for cause. And there's something that's lost there too. I mean, remember, the reason that we have a jury system in the first place is the wisdom of a group, and the discussions that people with different perspectives can have is the goal, or that's the underlying basis for it. And it certainly seemed like she's somebody who would have had a perspective to offer that maybe the others wouldn't have.
Well, she brings a completely different lens than a white man. I remember I think he got dismissed, but he was a white man from the suburbs, business owner who had never known anybody who had experienced discrimination.
Yeah.
I mean, it's just so critical to get the lenses of people of different races and ethnicities. It's just different, and it's valuable.
We did have a question coming in as it relates to this specifically. do they ever provide interpreters for folks who are on the jury? And then I also saw a question from somebody asking about, paying for childcare, or folks, who may be a single parent caregiver at home, folks getting paid for jury duty, which is a laughable rate. So I just want to put those out to the group to jump in on.
$20. That's what you get paid every day. So, yeah.
It's shocking that we give so little support to the people that we ask so much of. I lived for 10 years in Waco, Texas. And then if there was a death penalty case, I went to go watch the jury selection. And I later talked to a number of people in a project who'd been on death penalty juries. And they were paid $40 a day and received no other support and were largely traumatized for life. I mean, imagine sitting 12 feet away from someone and deciding whether they live or die and carrying that with you for the rest of your life. I mean, what we ask of these jurors in a trial like this is remarkable in terms of personal risk, the possibility of moral injury, and we give them very little support. It's almost an affront to human dignity the way they're treated.
That's also a perspective that we're missing too. I recall I had a number, like everybody does, of self-employed people, really creative people who would bring a different lens. People who worked at McDonald's or, working really hard at really hard jobs, but their jobs don't pay for them to be on jury duty. So there's a whole section of our community here that's left out of this process. People with single parents or with young kids or providing childcare. And that's a problem too. We're missing that lens. We're really only getting kind of a slice of Hennepin County demographics.
I wonder, as we close out our discussion on jury selection from each of the panelists, if you could share if anything that you've seen that's made you feel optimistic or concerned, and you all bring slightly different lenses to this. So, as you've watched this first week and a day, to the degree you've been able to watch and participate in that way, something that maybe is making you feel optimistic or concerned, or both.
It's difficult for me to answer that particular question because I think on one hand, the system is working the way it's designed to work. And that's part of the problem. I think Mary articulated this fairly well, where during jury selection, we equate questions with specific respect to someone's race or ethnicity, or their bias towards that as bad, right? So you can't ask someone if they're specifically racist. And if you have some kind of strong reaction or strong opinion about a bad act, so the video in this case, then you're off the jury. But we accept questions that are effectively go to the experience that one may have because of their ethnicity or because of their race, right? So you have a bad experience with law enforcement, largely because you're Black, and therefore we're going to kick you off of this jury. And I see the system working as designed. And I see all of the flaws inherent to that design being laid to bear in this particular case, because people still have questions about fairness. People still have questions about the composition of the jury. And those questions are never going to go away or be properly answered when the system is designed to create those problems and to create exactly the type of jury you're seeing being picked in this case.
I think the system is also designed, unfortunately, to allow officers to kill with impunity. I mean, that's what we've seen time and time again. And as someone alluded to earlier, the only conviction that we have seen in the history of the state of Minnesota of a police officer who has killed someone has been a Black Muslim Somali man who killed a white affluent woman. We cannot escape that reality in terms of how we look at this trial, how we think about fairness, how we think about jury selection, and how the process itself is playing out. That is the historical backdrop that we are looking at. And so as an African-American woman who stands up, who fights for justice, who stands in community with family members who have lost their loved ones to police violence, I wish I could say that I was optimistic in terms of justice being served in this particular case, but I have a lot of trepidation about the fact that once again, a dead Black victim is going to be demonized and treated as if he is responsible for his own death in terms of the information that is being presented. So it's like George Floyd against the system of white supremacy versus Derek Chauvin being tried, in a court of law that is fair, et cetera. So that definitely is concerning to me in terms of thinking about whether there will be justice in this case.
Nekima, I'm just gonna quick ask you, is there anything that you could see over the next week or so of jury selection or in this trial going forward that would, that you're looking for out of the system or out of the prosecutors here that might give you some hope for change?
I can't, right now it's hard for me to say that. I mean, I think just the fact that, which is really sad to me in terms of the bar being so low, the fact that these 4 officers were fired, the fact that they were actually charged, the fact that the Hennepin County attorney was removed from the case, all of those things are positive. Do they point towards progress in the larger system? Not necessarily. They point towards the power of the people standing up and taking to the streets and demanding all of these things that we've seen. But whether that plays out in the courtroom, I can't say. I want to be optimistic about it, but when I look at history, when I look at what I've seen happen here, it's hard for me to do so.
And let me just be clear, I'm not suggesting that I am optimistic. I just, playing my role here as the moderator, trying to get the conversation going. Mary or Mark, anything that you want to add?
Yeah.
Yep. Go ahead, Mark.
Okay. I mean, one thing is that I really worried before we started the trial that there would be almost no minority representation in the jury at all, just based on things I've seen in the past. And so far of the 9, we have 2 Black men, we have a multiracial woman, and we have a Hispanic man of the 9. We'll see what happens the rest of the way out. But so far, my fear that we would have, an all-white jury or something close to it, it looks like at least that is not going to be a part of this.
We started to see the defense's theory become more clear today when they were arguing motions, when they were talking about their medical examiner, their forensic medical examiner, and what he was going to testify to. And I worry a little bit about, is it going to be a battle of the medical examiners? And that takes me back to the original complaint that was filed that had a statement from Dr. Baker that was taken out of context, that he didn't see any physical evidence of asphyxiation. And I worry that that's in jurors' brains. I think somebody actually mentioned today they've heard of an autopsy, that kind of thing. And so I also worry, Nekima, as you said, that a lot of the testimony about what was in his system, and I know they're going to argue that he died of the drugs and the bad heart and his struggle against the police. That's their theory in the case. And I think that I can only imagine that that's going to be extremely difficult for community members to hear and traumatizing. It was not George Floyd who started this. And yeah, I do worry a lot about what that testimony is going to look like and what the impact will be on members of the community, because I don't think that's going to be pleasant at all.
Thanks, Mary. It's a little bit of a lead in to the last topic I want to cover here. We only have a few minutes left, and I do want to take a moment right at the end to share about some upcoming events that we have. But we are also providing at the Legal Rights Center legal support to folks who are out demonstrating and exercising their constitutional rights. And I want to invite Andrew to talk a little bit about a concern that has come up from our perspective as it relates to due process rights of protesters who could be arrested during the protests, and how we're responding to that and what some of the community concern is related to that. So I'm going to pass it over to Andrew and then allow opportunity for some brief comments before we close.
Okay, I'll try to be quick about this. In short, for those listening and attending this particular panel, the concern is that if someone is out protesting or demonstrating the trial of Derek Chauvin. So for example, Nekima mentioned a rally that happened this afternoon. If someone is attending a rally such as that and they're arrested and they're detained for processing, that detention will occur in a place where legal counsel is not then able to go and speak with the person detained. That is not typically how things work. Typically, if someone is detained even at a protest and they're being processed, they may be taken to the public safety facility, they may be taken to another facility, but they will have access to legal counsel. We're concerned that because of the security perimeter and because of the heightened security things that have been put in place by the county and the city, that those protections afforded by legal counsel and the access that legal counsel would have to individuals who were arrested and detained will not be present. Those are due process issues. We're worried about what will happen to people who are going through that process. And we are trying through our advocacy and through asking questions and talking to the folks who are responsible for organizing the security perimeter, we're trying to get that corrected. That's the short version of kind of where we're at and what's going on. And I don't know if any folks have questions or comments about that.
And I'll just add one quick thing is that we have not been able to get clear response from the city or the county on this. And the one inside response we've gotten is that folks will have to make other arrangements, which is incredibly concerning and deeply problematic as it relates to constitutional protections. So, I just want to put it out to, Nekima, I know you're out on the ground a lot and you joined our letter to the city and county on this. So an opportunity for you to speak to that and any concerns you have. And Mary and Mark, I can see your faces that you're concerned as well about this.
Is it because I know lawyers, public defenders have an opportunity to see clients. They've specifically said that lawyers will not have access to people who are being detained after they're arrested for protesting.
So effectively, they said that the response that we've gotten, insofar that we've gotten a response, is that legal counsel will have to make alternative arrangements to see their clients and to see individuals who are going through the detention processing, the process.
I think the distinction, Mary, is that they're not court appointed yet, right? So this is front end. We're sending folks in as jail support before the public defender's office would typically get appointed.
Okay.
Yeah, and so effectively they're saying you will not be able to see folks barring making some kind of alternative arrangement. We have no idea what that alternative arrangement is. We have no idea who to talk to for that to make those alternative arrangements. And we're trying to seek answers and clarification from both the city and the county.
And just a quick note on that. Something we all know is that the problem with alternative arrangements is confidentiality, that you just can't trust unless you're right there with the person. That, jails and detention centers are built to listen in on things, and that's a real danger.
Well, particularly with COVID, where they're having the non-contact visits with the plexiglass, they're open in the back. And so you can hear what people are saying. So that would be a concern, definitely.
Well, we are closing in right here at 7 o'clock, and I see folks saying in the chat, we need more time, and we will be back. We hope that our panelists will join us again. And thanks for indulging us here at the end with this conversation. We're deeply concerned at the Legal Rights Center about protecting the due process rights of our community members who are out exercising their First Amendment right to protest. And so we will continue to press on this. And thank you all for the conversation this evening. I do just want to close by, letting folks know that we do have some upcoming events that the Legal Rights Center is hosting. We are doing a Ask an Attorney lunch session online on Wednesday, March 24th from 12 to 1. And then community processing circles also being held online on Fridays from 4 to 5:30. That's a restorative space for folks to process. We will put links to that in the emails that you will get after this. And we, genuinely appreciate you all joining us here today. Big thank you to our panelists. I know we didn't get to all the questions. We have copied all the questions out of the Q&A and the chat, and we'll start our next live Ask an Attorney session with those. And you can expect we'll be back probably the week of March 29th with another community forum. Thank you all so much. Really appreciate you being here.
Thank you.
Thank you all. Thank you, Nekima. Thank you, Mary. Thank you, Mark. And thank you, Sarah.
Thanks, everyone.